And Ray requests an investigation of an attorney.
Mr. Cole, good morning.
Good morning, Your Honor. Madam Chief Justice, and may it please the Court, my name is Garrett Cole, and I represent the petitioner appellant, Mr. Thomas Atwater. Mr. Atwater brought this proceeding before the single justice after he received 2 letters. One from Bar Counsel, which informed him that the investigation Bar Counsel had conducted had developed no evidence that the conduct that Mr. Atwater had complained about to the board, the attorney had violated any professional rules of conduct. The second letter he received was from the general counsel of the board itself, telling Mr. Atwater that the single member had reviewed the file and that Bar Counsel had properly closed it. This matter came to the single justice not under 211.3. I struggled with the clerk in the county court. I struggled with the single justice. It's not a 211.3 matter. It's a matter brought before the single justice under the common law jurisdiction of the county court and of this court to regulate the practice of law. The single justice converted the matter, nonetheless, to one under 211.3, and this appeal followed. Now, this is not an appeal from the disposition, if you will, of Bar Counsel. It's not an appeal from the disposition of the board itself. It is an effort to inform the court of an apparent, evident problem in the administration of professional discipline in the Commonwealth. And the reason is this. Bar Counsel informed Mr. Atwater in a single sentence that the investigation failed to develop any evidence of professional misconduct. The evidence was admitted. The attorney admitted that he knew Mr. Atwater was unrepresented. The attorney admitted that he was representing a person, a client, with interests adverse to Mr. Atwater, and nevertheless the attorney admitted preparing an affidavit inculpatory of Mr. Atwater.
Was that in a deposition?
He informed Bar Counsel of that, Your Honor.
Okay.
That's in the response that he provided to Bar Counsel. Now, at his deposition, in a collateral matter, he elaborated on that, and you have that additional information in the brief. But we don't rely upon that. We point out simply that Bar Counsel's letter said there was no evidence, but it was admitted. The evidence was admitted. Now,
well, no evidence of misconduct, not no evidence.
Justice Cordy, it is per se misconduct in this Commonwealth for an attorney to advise a person.
Well, he's not advising him. I mean, that's your view of it. He's talking to him. He's a potential party on the other side. He's saying, look, I've got this case against you. We can settle it this way, or I'll take you to court. He's not advising him, is he? He's being a lawyer.
I believe he is. And the cases that we rely upon from Oregon and Cincinnati, from Ohio and Oregon, suggest very strongly that the preparation of an affidavit for a person who is unrepresented is, in essence, giving advice that is prohibited by 4.3b. This Court has said, under the analogous earlier provision of the disciplinary rules, that it would be okay to prepare real estate transaction documents. That's normally done, a mortgage or a promissory note or something, and you put it in front of an unrepresented person and ask them to sign it.
Well, certainly there was no confusion on the part of your client that this person was a lawyer, not his lawyer, right?
No
There was
confusion.
no confusion that your client thought, my goodness, this lawyer is my lawyer, he's advising me I should sign this affidavit. That's not,
No confusion whatsoever, Your Honor. It's quite clear, but that doesn't change the situation. The rule doesn't say if there's no confusion. The rule says other than to advise the person to seek counsel. And that's been the rule in this Commonwealth continuously for over 30 years. It wasn't the rule that the ABA adopted, as we point out in our brief, but the ABA model rule has changed, and it now conforms to the Commonwealth's rule.
but as I do understand, the attorney that you would like the board to investigate did say, maybe that was in his deposition, that he repeatedly advised your client to go seek a lawyer.
That's disputed. The
Okay.
attorney, that's disputed, Justice Cordy. The attorney says that he does that, he did that. Mr. Atwater's affidavit, which you have in the record, says that he didn't.
Was that affidavit filed when was that affidavit filed?
That was provided to Bar Counsel in response to to the attorney's
So that affidavit was filed after the complaint file was after there was an investigation and the file was closed?
No.
Okay.
No, the process is in 3 steps.
Okay.
Mr. Atwater files his request for an investigation. Bar Counsel sends the matter out to the attorney for comment.
Okay.
Comments come back, and Mr. Atwater filed a thorough rebuttal. And in that rebuttal, he pointed out 2 things. First of all, by affidavit, that what the attorney said was contested, but also that the attorney doesn't contest other things that Mr. Atwater says. When you read his filing with Bar Counsel, this is admission by silence. It's an adoptive admission. There's nothing to... I'm sorry.
Excuse me. Mr. Cole, what if Bar Counsel had said, dear your client, thank you for doing this. We recognize that the attorney said, did the affidavit that the Bar Counsel has concluded that it will not proceed.
Your Honor, our view and our suggestion to the Court is that that kind of discretion in the light of this record is not vested in Bar Counsel. Rule 7.2 gives Bar Counsel the option in this kind of circumstance, where it's a substantial, serious matter, and the evidence is available. It's substantiated. It's not unsubstantiated.
But isn't that contrary to everything that we've said about whether or not the Court will review decisions by Bar Counsel to proceed? It's not the same as, because there are slightly different considerations, but, the prosecutor decides not to proceed against somebody, who was weaving down a street and narrowly missed, running into a child. Parent says this person should be taken off the road, and for whatever reason, prosecutor decides not to do it. Very serious, very distressing, but doesn't the discretion lie with Bar Counsel?
Your Honor, not the way we suggest this Court's rule should be read. After the investigation proceeds to the point where there is substantial evidence of a serious violation, at that point, Bar Counsel's choice is to prefer the matter to the Board for proceedings. If it's unsubstantiated or frivolous or not worthy of pursuit or something like that, Bar Counsel has the discretion to which you refer. But what we see in this situation is not only did Bar Counsel say there's no evidence when the case is made out, when the charges are admitted in writing and by an adoptive admission by silence, by failure to refute, but we see a situation where that's the kind of decision at that point that the Bar Counsel should leave to the Board. If the Board determines not to proceed, that's another level, as Justice Ireland has described in our multi-tiered system or structure of bar discipline in the Commonwealth. But to give Bar Counsel the opportunity to determine, as you're suggesting, a prosecutor might determine that in the interests of justice weaving down a street doesn't warrant prosecutorial resources distorts, we suggest, the way in which this multi-tiered process should work.
Mr. Cole, because this is here as a 211-3, isn't our focus on, not on the Bar Council, but on the single justice?
Well, Your Honor, if I may suggest, it's inappropriately here under 211-3. We didn't bring it that way. That's what the single justice did. We appeal, and it is
Well, are you saying that the single justice committed an error of law
Yes,
by
Your Honor.
converting it to 211-3?
Yes, Your
He
Honor.
doesn't have the power to do that?
Well, Bar Council agrees with us that this kind of subject matter is not cognizable under 211-3. We didn't bring it under 211-3. The Board of Bar Overseers agrees that we couldn't bring it under 211-3. The single justice simply converted it, and I tried to convince him otherwise, moved for reconsideration, told him that this was just the common law jurisdiction of the county court, that the county court should respond under that jurisdictional head, to no avail. So we are here now, but I don't think it's a 211-3 matter. And therefore, I think it is before the court in a basically plenary condition. But the relief that we're suggesting is not that the court decide what to do, but to send it back to the single justice for appropriate proceedings. That's what we asked in the first place.
Thank you, Mr. Cole.
Right.
Mr. Ogman?
Thank you, Your Honor. May it please the Court, Assistant Attorney General James Argwin on behalf of the Board of Bar Overseers and the Office of Bar Counsel. This is an appeal from the single justice's denial of a petition for general superintendents. The petition challenged the Board and Bar Counsel's decision to close petitioner's complaint against an attorney without imposing discipline. Because there was no abuse of discretion or other clear error of law, the single justice's decision should be affirmed. The settled rule in this Commonwealth and in every other jurisdiction to address this issue is that complainants in bar disciplinary proceedings lack standing to challenge a disciplinary board's decision to close a complaint against an attorney without imposing discipline. And it does not matter whether the petition here was filed under General Law Chapter 211-3, as the single justice assumed, or as petitioner contends under the court's inherent authority to supervise the practice of law in the Commonwealth. Any party seeking to invoke the court's jurisdiction and the court's authority must have standing to do so, and the settled rule in all jurisdictions, including Massachusetts, is that complainants in bar disciplinary proceedings lack that standing. Now, the petitioner attempts to get around this settled rule by claiming that he's not seeking private relief, that he's acting as some sort of a private attorney general in the public interest. But the relief sought in the petition belies that contention. The petitioner asked the single justice squarely to direct the Board and Bar Counsel to reopen their investigation and to impose discipline against this attorney. The court addressed a very similar situation in the Callahan versus the BBO decision and held that the petitioner in that case lacked standing, regardless of how he chose to characterize his request for relief. Thereas here, the petitioner claimed that he was not appealing Bar Counsel's decision to close the case, but was rather trying to bring some general matter to the court's attention, and the court rejected that contention, and it should do so here. This court has charged the Board and Bar Counsel with primary responsibility for supervising the practice of law and investigating and prosecuting allegations of misconduct by attorneys. And only in extraordinary circumstances the court said that it will interfere with the Board and Bar Counsel's decision to exercise a discretion in determining the scope of any investigation and in deciding what matters to prosecute. The record here discloses no such extraordinary circumstances, which in prior cases, just in the Barrett decision released last term, this court indicated that extraordinary circumstances would arise where there was some showing of bad faith or other kind of egregious misconduct on the part of Bar Counsel in the conduct of an investigation. There's nothing of the sort here. Bar Counsel investigated petitioner's complaint, and based on that investigation, Bar Counsel determined that the matter should be closed without discipline. Bar Counsel also notified the petitioner of his right to obtain review of the Bar Counsel's decision before the Board. Petitioner invoked that right. A single member of the board conducted an independent review of the entire file that was before Bar Counsel and affirmed Bar Counsel's determination. Under the settled precedent in this court and on other jurisdictions, no further review is permitted. And so for all those reasons, the single justice's order denying the petition for superintendent should be affirmed.
Thank you, Mr. Alvin.
Thank you.